Aiboan, Vanakkam, Assalamu alaikum, and of course, a very, very good evening. Welcome to this, the 9th in our special series of law reviews presented to you by AmCham Sri Lanka. And today, once again, an eminent panel that will be speaking to us on money laundering and corporates, how it pertains, what are the risks, what are the implications, and of course, what does it mean to you as a corporate. So without much ado, let me quickly introduce you to your panel, which is a very eminent panel of speakers, and then hand over to your moderator for this evening. Joining us today on the AmCham Sri Lanka Law Review Series, Mr. Kalingi Indratissa, President's Counsel. Indratissa enrolled as an attorney at law of the Supreme Court of Sri Lanka with first-class honours, placed first in order of merit in 1985, and functioned as a public prosecutor attached to the chambers of the Attorney General of Sri Lanka from 1986 to 1991. He thereafter became a member of the private bar and has been since 1991. Mr. Indratissa was recipient of the British Council Scholarship for Professional Training for Commonwealth Youth Lawyers in 1994 from the Institute of Advanced Legal Studies, the University of London. And among many international representations, he has attended 5 SCA and EWE conference and the signing of the agreements as Sri Lanka signatory on behalf of SLT PLC, KL Malaysia in 2014. He has attended the World Mobile Congress in Barcelona, Spain in 2014, was a member of the Sri Lanka delegation to the Geneva Human Rights Session in April 2012. In 2003, he visited Japan as a leader of the Sri Lanka delegation to participate at the Law Asia Conference. Moving on, he has served as a senior lecturer and as an examiner at the Sri Lanka Law College for subjects like criminal law, evidence, legal history, civil procedure, criminal procedure. And Mr. Indratissa was also a member of the Council of Legal Education of Sri Lanka. He has held many academic and administrative positions and authored a vast variety of legal publications throughout his career. And of course, Mr. Indratissa needs very little introduction, both to lawyers and non-lawyers. Next, we have Mr. Ayush R.A. Singha, Deputy Director of the Financial Intelligence Unit of the Central Bank of Sri Lanka. Mr. R.A. Singha is the Deputy Director of the FIU of the Central Bank and has a central bank career spanning for 16 years, having served in the departments of Legal and Compliance, Economic Research, International Operations, Employees Provident Fund, and the Special Investigations within the Central Bank. Mr. R.A. Singha is an attorney at law by trade since 2001, and prior to joining the Central Bank, was a State Counsel of the Attorney General's Department, prosecuting in the High Court jurisdictions of Colombo, Hambantota, Kegod, and Palapitiya. Next, we have Mr. Vishwa Dilivera Tenakon, attorney at law. Mr. Tenakon is a practitioner in Harsdorf, both in the original and appellate courts. He served as the Assistant Secretary of the Bar Association of Sri Lanka from 2019 to 2020 and was the Editor-in-Chief of the Junior Bar Law Journal in 2013 and the Harsdorf Law Journal 2020. Colombo Law Society. He has functioned as Secretary of the National Law Conference in 2020. He is also involved with public interest litigation in Sri Lanka and has a Bachelor of Laws from the University of London and a Master of Laws degree from the University of Colombo, with a focus on environmental law, constitutional law, and criminal justice. Your moderator this evening, Mr. Amir Maharouf, attorney at law. Mr. Maharouf is an attorney at law holding an LLB from Staffordshire University, UK, and an LLM in International Business and Commercial Law from the University of West London. He's also an associate member of the Chartered Institute of Arbitrators. He currently occupies the position of an associate at the chambers of Mr. Guerra de Souza, President's Counsel, and is a legal practitioner specializing in commercial litigation and arbitration. Amir, over to you for what I'm sure will be a very interesting and enlightening session this evening.
Thank you very much, Rai. Good evening to everyone. So money laundering. Money laundering is a serious financial crime that is generally employed by both white-collar and street-level criminals alike. Most financial companies have anti-money laundering policies in place to detect and prevent this activity. Money laundering is the illegal process of making dirty money appear legitimate instead of ill-gotten. Criminals use a wide variety of money laundering techniques to make illegally obtained funds appear clean. Online banking and cryptocurrencies have made it easier for criminals to transfer and withdraw money without detection. Thus, the prevention of money laundering has become an international effort. With that, I'd like to move on to my first question, and I'm directing that at Mr. Karlinger, the President's Counsel. Sir, would you be kind enough to brief the audience on the history and concept of money laundering?
Yes, thank you, Amit. Thank you very much. And I'm very grateful to be in this panel at this discussion this evening. When you take the concept of money laundering, which is one of the most contemporary topics in the field of law, and also which has a direct relationship to the corporate world, ever since the beginning of the human race, I believe there were two types of making money: the lawful way and the not so lawful or illegal way. But if you really go to the history of the modern concept of money laundering, you will find that in the 1920s and in the 1930s, the mafia was a very powerful entity or an individual or a group in the United States. So basically, what invited the attention of the rulers at that time and the legal system with regards to the concept of money laundering was the illegal accumulation of wealth and money by the mafia through extortion, gambling, prostitution, and also bootlegging. Those were the four basic things that the government was concerned. The rationale behind the concept of money laundering and the need to curb money laundering is, if you permit people who use illegal mechanism to acquire money, there cannot be a comparison between people who make lawful income and those who are involved in illegal income. They will have the power. They will first gain the economic power by acquiring assets, properties, and acquiring money, accumulating wealth. Thereafter, they will go into other tiers, because it was proven, especially in the context of Latin American countries, people who were behind drug cartels gradually became owning shares of banks, banking institutions, and they became stabilizing themselves in the financial and the economic sector. So the next line is the political setup. So that is what, if you are a person or an organization which has a reputation of acquiring money in an illegal form, that is what the money laundering laws or anti-money laundering laws would make an attempt to control. Now, if you go back to history on a very brief, with regards to the limited time, let's discuss briefly. 1920s and 30s, we saw the bootlegging, the prostitution, and the other related areas taking place in the United States. Then came the trial of Al Capone in 1930, where there was tax evasion, revenue evasion. That is a turning point of the concept of money laundering. Then in the 1980s, the entire world was combating narcotics. The war against narcotics started in 1980s. And then the real turning point of the modern concept, where all these laws and international conventions, international discussions took place, was the 9/11 attack in 2001. So there are three segments that you can derive from this. The traditional segments of prostitution, bootlegging, gambling, and related areas. Secondly, the narcotics, which came in the 1980s, and then suppression of terrorism and terrorist-related activities, which actually came to a peak and noticed by the United States government in 2001. So there are two things, Amir. That is, number one, when you understand the rationale of money laundering, you must remember, initially, it was considered to be organized crime. But today, even for an individual act, for an individual incident, the laws of money laundering will extend and people can be dealt with that. So that is basically my answer to your question. You have to put on your mouth.
Amir, I believe you're on mute.
Yeah.
Before you go on to the next question, actually, let me just jump in and remind our audience that we will be taking audience questions towards the final 10 or 15 minutes of the session. So if you want to share any questions, please feel free to type it up into the Q&A box, not the chat box. And on Facebook and YouTube, you can go ahead and post it as a comment, and I will take it and share it with the panelists. Over to you, Amit.
Thank you. So moving on from what you said, could you give us a general overview of the legal platform in Sri Lanka, or the regulatory framework with regard to money laundering that is currently in place?
Yeah, that is basically there are three basic laws which deal with the concept of money laundering. And I believe that those are the matters for the discussion today. Number one, you have the Prevention of Money Laundering Act and the amendment of 2011. The Prevention of Money Laundering Act deals with how do you prevent, what are the offenses, what is the investigation process, what are the powers of the FIU, that is Financial Intelligence Unit, and how do you deal with the offenders and who becomes liable. Secondly, you have the Financial Transactions Reporting Act, which is very, very important, especially in the context of banking institutions and non-banking financial institutions. Then thirdly, you have the Convention Against Suppression of Terrorism. Those are the three laws. Now, those three laws will outline to you and demonstrate the concept behind money laundering. Terrorism, suppression of terrorism, Convention Against Suppression of Terrorism Financing Act deals with issues of financing terrorism, terrorism-related financing, either granting money or collecting money. That is prohibited. Then as far as Financial Transactions Reporting Act is concerned, that is one of the most important things. Now here, I would like to explain, if you recall the Easter Sunday attacks, Amir.
Yes.
When the Easter Sunday attacks, now I told you basically there are three laws: the Prevention of Money Laundering Act, then Convention Against Suppression of Terrorism, then Financial Transactions Reporting Act. Those are the three laws. Apart from that, there is another important law. I think Mr. Ayeshari Singh will have to take cognizance of that. That is the Computer Crimes Act. No one knows the connection of Computer Crimes Act towards this concept of money laundering. If you go through sections 5, 6, 7, 8 of the Computer Crimes Act, there are circumstances where things which are affecting the national economy and national security, if committed by an employee in a particular organization, the responsibility of the employee and the employer both are discussed in terms of the provisions of this act. So if you keep yourself open to a situation where an employee misuses the provisions of your infrastructure, IT structure, that might result in you being held responsible. That is one of the things. Now, money laundering can take place in the years to come in that situation. Now, when you take these three acts, take the three acts, you will find Section 3 of the Money Laundering Act is the main provision. That deals with three types of people: the launderer, the person who is involved, any person who abets it, who helps him to launder the money, and thirdly, any person or institution which is the platform through which it is laundered. So it can be a bank, it can be a finance company, it can be a leasing company, it can be an attorney at law. Because you can go and invest your money with an attorney at law. You can go and invest your money with a company, and that company becomes responsible in terms of Section 3. So therefore, three types of offenders: the principal person, the launderer; secondly, the person who abets; and thirdly, any institution which is used as a platform to commit these offenses. That is under the Money Laundering Act. Then Financial Transactions Reporting Act is very important for anybody dealing with business, especially in the business of financing. Banks, finance institutions, finance companies, and even leasing institutions. Because they have a duty in terms of the provisions of the statute to report any suspicious transaction. Now, I must tell you, it was alleged by the law enforcement authorities that certain employees of a particular financial institution prior to the Easter Sunday attacks were involved in passing certain transactions unknown to them or known to them for the purpose of terrorism or connected to terrorism, or where there could be a reasonable suspicion which arises. Now, how would a suspicion arise? That is why KYC, know your customer, is introduced in both these types. So basically, to sum up, number one, the majority of the offences are listed in Section 3 of the Money Laundering Act. They are connected to the other two statutes, and there are certain responsibilities arising under the Financial Transactions Reporting Act and the Suppression of Terrorist Financing. Are you okay with that?
Yes, very clear, sir. Thank you. The sanctions that are imposed on those who are found guilty of money laundering, in your view, would you say that the punishment fits the crime, or do you believe that there is a change that needs to be made in terms of how sanctions are imposed? I place this question before you, sir, on the backdrop of what we generally see in respect of companies that are, or let's say organizations that are sometimes found guilty of money laundering. It's just a fine. They pay the fine and move on. So in that backdrop, would you say that is it a question of whether the law is there and not being implemented properly, or is there a change that needs to be made to it?
Yeah. Number one, the law is there. The law in Sri Lanka is basically the same as the laws in other countries. The 2011 amendment came because certain more offences had to be enlisted and included in the schedule of offences. That is why it came. Now, where do we go from here? Now, first thing that we must realize is the Money Laundering Act and the experiment. We are in an experimental stage. Number one, the government does not have the infrastructure to conduct investigation. That is one of the biggest problems. Not that they don't want to. They want to, but the infrastructure. Because money laundering is not walking into a bank, showing a gun on the face of a person and robbing money out of that situation. No. It involves a lot of, sometimes it could involve computer networks. Sometimes transactions cannot be traced. It involves a lot of forensic analysis and research. So number one, in my opinion, as far as money laundering offences are concerned, the investigations must be conducted by specialized units. The police themselves, a local police cannot do that. There must be an institution that is separately set up under our legal system, which consists of police officers, accountants, then other bankers, people with finance experience, prosecutors, forensic experts, IT consultants. All those people should be in one umbrella. Otherwise, it will never be able to achieve the objective of the law because we were at different places. So one of the things that the state should consider is bringing them under one umbrella. The second thing is, now we are going through a process where the money laundering prosecutions are commencing and results will come in time to come. So one of the things is admissibility of evidence. Some of these evidence, we have to get rid. We have the Computer Evidence Act of 14 on 1995, but there are technical issues in that statute that has to be modified. Money laundering cannot, it can't be delayed. Secondly, what I want to say is you must look at the innovative methods because always the criminal is ahead. You identify and pass a law today, he has only to find the loopholes in the law. So he doesn't have to think much. So therefore, since the criminal is ahead, he thinks differently. So you have to identify how to bring all these prosecutors, investigators together. FIU, Mr. Arisinghe will be able to comment on that. FIU also should play that role. They should be consulted, they should advise. And secondly, what I suggest is the method of proof, the mechanism of proof has to be more simpler and acceptable. And not, of course, Remember this, any government in any country can abuse any law. If you don't like my face, you can land me with a money laundering charge. So there are two things that you have to be mindful of. Money laundering is a menace. Yes, of course. It must be prevented. Yes. But the abuse also should not be permitted. So there must be a balance. There must be a transparent situation where the investigations are transparent. But at the same time, any room for abuse also must not be left. Because otherwise, when you go through the provisions of Section 7, 8, 9, and 10 of the Money Laundering Act, where there is provision for forfeiture of property, freezing of property, confiscation of property, unless there is another system to double check, because freezing of property is left in the hands of a assistant superintendent of police. That is not satisfactory in my opinion. Because if I have acquired money in a legal way, you come and land a freezing order on me. It is up to me. All my assets are frozen. I can't do anything. Then I have to fight and get it out. That should not be the case. There must be a tested individual or tested organization which prevents or which acts in respect of that. So what I say, the law is there. Enforcement must be more practical. The people who are involved in enforcement must be more trained. The legal system, also the judges will also have to realize on the one side, they will have to realize the seriousness of the offense. On the other hand, you must protect the rights of people. So that balance is important. Then the proof of method of proof should be more simple. Those are the comments I would like to make in a nutshell.
Thank you very much for those insightful comments, sir. I would now like to pose my next question to Mr. Vishwa Dilivera Tenakon. Vishwa, how would you say the laws in relation to money laundering applies to corporates?
Thank you, Amir, and I thank the American Chamber of Commerce for having me involved with this very timely topic. In answer to your question, Amir, we have to look at it in three ways, and that is as it has different regimes, different application depending on the act that we are dealing with. If we start off with the Prevention of Money Laundering Act, as per Section 2, it says that the act shall apply in relation to a person who commits an offense under the provisions of this act. So a person has been defined under Section 35 of the Prevention of Money Laundering Act, and that would include a body of persons. This, read together with Section 2 of the Interpretation Ordinance, would mean that a person includes any body of persons, corporate or incorporate. So by Section 2, the rules or the offences and the regulations that have been introduced by the Prevention of Money Laundering Act is applicable to corporates. Also, Section 2, subsection B, deals with an institution. It says that an institution which is used for the commission of an offence under the provisions of this Act, which institution is carrying on business in Sri Lanka and is either incorporated or registered in Sri Lanka, or is either incorporated or registered as a branch of a bank incorporated or registered outside Sri Lanka, such an institution would also come under this regime. So I think before looking at some of the some of the, like, quite briefly, some of the substance contained in the Act, I think it's important to for our listeners to understand who under the money, who would be liable in terms of a corporate, who are the actors in a corporate who would be liable in the event they are found guilty of an offence under this Act, or an offence of money laundering. And as per Section 18 of the Money Laundering Act, it says where an offence under this Act is committed by a body of persons, then if that person is a body, if that body of persons is, subsection A says, a body corporate, then every director or other officer of that body corporate shall be found guilty of the offence. If it's a firm, subsection B says every partner of that firm shall be found guilty of an offence. And C, subsection C, deals with an unincorporated body, and it says that in an unincorporated body, other than a firm, every individual who is a member of such body and every officer of that body responsible for its management and control would be shall be guilty of an offense. So this is there is also an important proviso in that section, which says that provided, however, that no such person shall be deemed guilty of an offense if he proves that the offense was committed without his knowledge or that he exercised all due diligence to prevent the commission of the offense. So that is a very important thing when it comes to the guilt of an offender, of the person that we mentioned. If a body corporate is found culpable under this law. So this is dealing with the Prevention of Money Laundering Act. And then also Mr. Indratissa pointed out that we do have certain other acts that deal with this. And if we look at the Convention on the Suppression of Terrorist Financing Act, then as per subsection 3 of that act, it says that it refers to, I don't necessarily need to go into the operative section where it describes the offense, but in terms of the application of this law to corporates, subsection 3 of section 3 says where an offense specified in subsection 1 or subsection 2 of this section is committed by a body of persons, then every member, director, manager, secretary, officer, or servant of such body of persons shall be guilty of such offense. Unless, again, we have a caveat which says unless it can be provided, unless it can be proved that the offense was committed without their knowledge or that they exercised all due diligence to prevent the commission of the offense. So that is dealing with the Convention on the Suppression of Terrorist Financing Act. Then we move on to the Financial Transactions Reporting Act. So the application of the Financial Transactions Reporting Act is for institutions which have been defined under the Act, and it deals with, as per the definition under that Act, section 33, it says an institution means any person or body of persons engaged in or carrying out any finance business or designated non-finance business within the meaning of this Act. So clearly, Amir, the Financial Transactions Reporting Act deals with finance business. So the finance business, so it's very important, bankers and anyone dealing with the finance business needs to be super cautious and also extra diligent with their activities, because we have now three regimes that deal with or set up some obligations for these businesses. So finance business deals with, it's also defined under section 33. There's a list, but finance business is relatively straightforward. We also have this concept of designated non-finance businesses. So a designated non-finance business, especially when it comes to corporates, it's very important to know that individual and collective portfolio management, investment administering, managing funds for someone else, safe custody services, trustee administration, investment management, and or superannuation schemes, even real estate agents, when they are involved in transactions for their clients in relation to buying and selling of real estate, they get caught up in the Financial Transactions Reporting Act. And I will show you how there's certain responsibilities that have been cast on these individuals who come under this act, and they need to conduct themselves in a way that that they don't get caught or they are not suspected of having committed any offenses. Also, Amir, as Mr. Indratissa pointed out, even lawyers, notaries, other independent legal professionals, and accountants, even they are they fall under the definition of non-designated finance businesses. So mainly to say that is as a direct question, as a direct answer to your question about how this concept applies to the corporate. So there is the application depends depending on the act that we are discussing, and in any event, if you're looking at, say, money laundering, it also deals with even the Money Laundering Act deals with finance business or designated non-finance business.
Vishwa, now coming back, now we know, we've understood that there's a wide array of people, individuals, corporates that now fall within the ambit of the money laundering regulations. Mr. Indratis at one point pointed out the importance of a know your customer from a KYC. What are the controls that corporates can put in place in order to sort of create that safeguard in order to be aware or to cover that due diligence factor when it comes to the money laundering legislation?
So the aspect of the mental element is a very important concept that the Money Laundering Act speaks about, because it is required that you know or you have reason to believe that the property is coming from an illegal source or an unlawful activity. But again, it's very important, Amir, at the very first as a very first step for all corporates and anyone who's dealing with money or who's regularly involved with transactions of any nature, and especially if they're directors, to educate their employees about these three acts. And the finance business reporting, the Financial Transactions Reporting Act specifically requires people who are engaged in this finance business or designated non-finance businesses to create awareness amongst its employees about this concept of money laundering and how their institution can directly or indirectly be used in the commission of the offences of money laundering, even even terrorist financing. So I think as a first step, one of the most important things, and that's why I'm very grateful to the American Chamber of Commerce in Sri Lanka for having this webinar, because this is it's very important that people know about these concepts. And certainly, I mean, you would know very well that the ignorance of the law is never an excuse. So I think as a first step, these corporates, they need to be well aware of these regimes. And moving on, I think it all depends. So we have, broadly speaking, we have section. So money laundering, it comes under Section 3 of the Money Laundering Act. Apart from that, there are certain other offences that have been specified in the Money Laundering Act. And one thing, just much like in cricket, Amir, it says that there is where you need to disclose, where a cricketer or a participant needs to disclose an approach made by a person if they are corrupt. In such an event, there is similarly under the Money Laundering Act, there is a duty to disclose, and that section says any person who knows of or has reason to believe from information or other matter obtained by him in the course of any trade, profession, business, or employment carried on by such person, that any property derived or realized from any unlawful activity shall disclose his knowledge or belief as soon as it is practicable to the Financial Intelligence Unit. So this is again an offence that is stipulated and provided for in the Money Laundering Act, in that it says, subsection 5, I was dealing with section 5, section 5, subsection 5 says that in a prosecution for an offence under subsection 2, it shall be a defence for the accused to prove to court on a balance of probabilities that he had reasonable grounds for not disclosing his knowledge or belief. So you need to establish the reasonable grounds. So it's very important that corporates take steps, and this is where due diligence comes in. as Mr. Indratisa said, know your customer. KYC, it's a very important concept, and you need to be able to, if there is a prosecution, prove. And see, I mean, as per section 5, subsection 5, the burden has now been shifted to the accused to prove that he had reasonable grounds for not disclosing his knowledge or belief. So similarly, if you go into section 6 of the Money Laundering Act, they deal with a duty to conceal information, and this is to conceal information with regards to investigations that that may be going on. And then also we find under section 20 an offense which deals with the falsification of documents. I don't want to necessarily go deep into the offenses, but just to say, depending on the offense, there are certain defenses that the Act itself provides for. So it's important that the corporate or the directors are able to show that they have complied, or that they have taken steps, or that in fact they were unaware of the of the commission of the offense, or the ingredients of the offense, which may have been committed by the use of their corporate. I mean, also, I must say that the when we're looking at the Financial Transactions Reporting Act, number 6 of 2006, it provides, or it gives a lot of there's a lot of requirements that it stipulates for persons or corporates that come under the finance business or designated non-finance business. So in that situation, under that, there are certain sections that actually it introduces a very stringent regime that the finance businesses or the designated non-finance businesses should follow. And some of them, if I may keep it quite brief, is section 2 of that act says that you should implement customer identification. So essentially, it's know your customer. You need to know your customer. So section 4 deals with the maintenance of records and retention. As per the act, it says that any record of any transaction, you need to hold the records for up to 6 years, right? So it's a requirement of the company. So any company, any person, any business that comes under the Financial Transactions Reporting Act needs to be well aware of the obligations that they have. Otherwise, they will be held liable. Not only that, Amir, as per section 14, actually as per section 6, 7, 8, and 22 of the Acts, there is a requirement that you implement and also report to the Financial Intelligence Unit of the Central Bank about any transactions that have been listed in the Act, which may cover any unlawful activity. And we also find section 14, which also says that awareness needs to be created among employees regarding money laundering laws and laws relating to financing terrorism. Not only that, there is also a burden cast on the employers to screen persons, hiring them as employees, when you're hiring them as employees, and also to establish an audit function to test its procedures and systems for the compliance with the provision of this Act. Even to train officers and employees and agents. All of those things come under the Financial Transaction Reporting Act. And may I also say, may I also bring to the notice that in 2011, the Financial Intelligence Unit actually fined 3 companies under these regimes for not having enough, for not having sufficient customer due diligence. So, see, as Mr. Indratisa pointed out, the laws are there. The agents are a bit slow to implement the laws and to conduct themselves as according to the law. But when they do start catching up, Amir, if the corporates have not taken the correct steps. If they have not been diligent, then most certainly there would be a form of culpability under these laws.
Thank you very much, Vishwa. So from that point where you left off with regard to the Financial Intelligence Unit and how they operate, my next question is to Mr. Ayesh Aryasinghe. Mr. Aryasinghe, could you briefly give us an overview of the role of the Financial Intelligence Unit?
Thank you, Amir, and good evening to all of the viewers, the listeners, and as well as to my fellow panelists. As my fellow panelists, Mr. Indratis and Mr. De Oliveira mentioned, so most of the powers that are vested with the Financial Intelligence Unit comes from the Financial Transaction Reporting Act. Sri Lanka's FIU is basically what we call, in terms of the types of FIUs out there in the world, we are an administrative FIU. Now, what we have as an administrative FIU is that we gather certain information, we do certain analysis of that information, and then we disseminate it to the law enforcement authorities. We do not function as investigative arm of the law enforcement authority. We are a collection, analysis, and a dissemination arm when it comes to that. We have an autonomy, and that autonomy is assured by having ourselves attached to the to an independent institution such as the central bank. Although we are there within the central bank's umbrella, we do not exactly link ourselves in all aspects, only with regard to logistics only, that the Financial Intelligence Unit is vested under the umbrella of the central bank. Now, having said that, we collect that information through three instruments. First one is the cash transaction reports. The other is the electronic fund transaction reports. And both of these are having a threshold value of any transaction that is carried through the institutions, which is above 1 million rupees. The amount was set in 2008. And apart from that, we have a unique reporting requirement, which is called the suspicious transaction report. Now, suspicious transaction report has not got any threshold. It can be even 50 rupees, it can be even 100,000 rupees, it can be even crores of millions of rupees. So irrespective of that, if there is any suspicion that the institution, our institution here is a capital I institution, which encompasses both designated non-finance institutions as well as finance businesses or financial institutions. So once that carries out, then of course the analysis dissemination part is carried out, and then we disseminate that information where we see that there is money laundering and there is definite suspicion of money laundering or related predicate offense or an unlawful activity that might have led to a money laundering offense. We pass that on to the law enforcement authority and not to any police within any particular jurisdiction. We pass that on to the financial investigation arms of the criminal investigation department. So that's the basic gist of what FIU does. And apart from that, we have other mandates, which is partly second mandate would be the supervisory function, where we do carry out the supervision of the institutions that comes under our reporting requirements to see whether they carry out what they are supposed to do by law. And as Vishwa also mentioned, we do sanction them if we find they have erred in certain compliance requirements from time to time. Even within this year, there were a number of instances you may have seen in the press that we have issued certain fines. We have a fine of rupees 1 million per any occasion of non-compliance. And there could be multiple occasions of non-compliances, and then institutions do get caught up in that. So that's in a nutshell what the FIU does.
Mr. Aryasinghe, does the FIU have, in addition to the imposition of sanctions, is there anything that the Financial Intelligence Unit can do to, for example, issue directives or regulate certain institutions, or is there anything of that sort that the FIU is able to do?
Yes, Amir. Under Financial Transaction Reporting Act, FIU has derived its power through that particular act, we like to call it the FTRA. Now, under the FTRA, Section 2 refers to specifically the know your customer, or rather a little bit beyond that know your customer requirement, which we call the customer due diligence. Know your customer is basically like touching a keyboard and identifying there are keys on it. Customer due diligence will be like pressing, getting a tactile response to see what sort of a customer he is and what sort of a requirement or the risk is emanating from that customer. And to get that, we have issued under Section 2. And then there are other provisions such as under Section 15, subsection 1 of the Financial Transaction Reporting Act. And if you go to the Financial Intelligence Unit website, there are a plethora of regulations that we have issued since 2006, the year of our inception, and since 2007 onwards, specifically between the period of 2016 to date. There are a number of instruments, directions, rules, circulars, and we even have consulted certain legislative amendments as well.
So if I am to have understood you correctly, Mr. Aryasinghe, is the financial intelligence unit scope limited to a particular category of institutions, or is it as broad as how the legislation keeps it out to be? Is it only finance institutions, or do you also cover that non-finance aspect that Vishwa spoke of?
We do catch the identity is basically institutions, and these institutions are capital I institutions. We call it capital I institutions. Capital I institutions are of twofold. One is finance businesses, and the other is designated non-finance businesses and professions. Of course, the profession part have been dropped out, but nevertheless, the professions are there. Finance businesses, as Vishwa and Mr. Indra both explained, is set out under the under the definition part of Prevention of Money Laundering Act, as well as the Financial Transaction Reporting Act. Now, under the Financial Transaction Reporting Act, Section 33 identifies both these categories. The category of the institutions are divided into, then again, finance businesses and designated non-finance businesses. Now, the professions which Vishwa and Mr. Indra both spoke about, the attorneys, the notaries, accountants, trust and company service providers, they're also caught up in this. So apart from the usual businesses that we do identify as, being the usual culprits of a possible money laundering suspicion, apart from that, the professions are also caught up. Why? Because they can be what we call the gatekeepers. They are the ones who have special access to certain areas due to their professional expertise. They can form companies, they can create certain shelf companies to hide certain wealth behind certain closed doors, and things like that allows them, they can reveal or not reveal certain financial disclosures. They can distort certain information to certain ways, put certain conditionalities so that the truth is covered behind certain conditions. So these makes the professions or professionals more liable to aiding and abetting, and also maybe directly culpable to the offense of money laundering. So that is there. So there's a vast gamut. If I am to put it in a nutshell, right, I think about 90% of the financial sector, and maybe almost the same size in the non-informal sector, are also taken in. Apart from that, if the Minister of Finance gets he can mandate or he can prescribe a certain sector or an institution or a certain set of professionals to be included within these categories.
Thank you very much for all those insightful ideas. We have a question from the audience. Can I place that? Anyone from the panel can answer it. The question reads, does the legal framework on money laundering capture white-collar crimes?
Can I take that, Amit?
Yes, sir.
There is nothing called white-collar crimes in the law. First thing that you have to realize is, it's a word that we used in the normal discussions or conversations. The term white-collar crimes is used or was used in the past to define offences which are committed by people in comfortable and cushioned positions, right? As opposed to the street fighters, right? Now, white collar crime, there are nothing, no definition. First thing that you have to realize is there are nothing called white collar crimes. But in the context of the term that it is used, if you look at section 35 of the Money Laundering, most of the offences which are listed there can be committed by a man on the road or by a person seated in a comfortable and a cushioned room. So every offence, what we call generally as white collar crimes, are covered by section 35. So that is the answer that I can give you. Can I? Right. Please proceed. At the question time, I have a question for Mr. Arias.
That is the only question we have from the audience. But Mr. Idris, I also have a question, and I think you would be most suited to answer this question, because you categorized, different. You categorized the kind of types of money laundering at the very beginning. You were talking about bootlegging and prostitution.
Yes.
You were talking about drug cartels and then terrorist financing. Now, this is a very practical sort of example that I'm asking. Say I want to sell my car. A gentleman comes up to me and offers me money, probably even sometimes above the market value. He comes with cash. I sell my vehicle to him. I don't ask him, where do you get the money from? I only tell him, right, this is the amount I want, sign the papers, take the money, and he goes off. I don't know where he has got that money from. What could be my possible liability as a seller? Or is there a chance of me being taken off guard and, found to have done something wrong because I have been part of that in the event that money is ill-gotten?
No, in the first place, you must understand under section 3, Amir, there is a mental element involved. Knowledge, any person who has reason to believe, willfully, those are the words which are used. So now, in the context of the mens rea or the mental element being embodied in those sections, now as far as you are concerned, you have bona fide purchasers, you have bona fide sellers also. In the context of money laundering, you have got money, but your transaction is a bona fide transaction. Now let us say that man pays. Now say for example, you own a vehicle which is normally operated and run by a VIP, so-called VIP, something looking like a VIP's vehicle. I come and purchase that vehicle over and above the normal price. You want to sell it, I want to buy it. Now in that context, what can you do? Right? You have to either accept my position or not accept my position. Now what do? I use that vehicle for the purpose of gaining entry to a security area zone with explosives, and it goes off. When you track back, origin is found to you and to me. Right? Now, as far as you are concerned, you have done an act, that is the act of selling that vehicle to me without any knowledge of what the future of this vehicle or what I have. Two things. You don't know what I am going to use this vehicle for. Secondly, how I have acquired this money, you would know. So as far as you don't have that knowledge, you cannot be brought in under section 3 of the Money Laundering Act, Prevention of Money Laundering Act. That is very clear. Ms. Arising, the question I wanted to pose to you is this. Under section 4 of the Financial Transactions Reporting Act, as stated by Vishwa, every financial institution has a duty to protect their records. Now, Sri Lanka has a huge problem because technology-based legislation started being introduced into our legal system in 1995. The first act based on technology-based law is the Computer Evidence Act, Special Provisions, Act number 14 of 1995. But we have a problem because we don't have a Data Protection Act. When we don't have a data protection act, the period of protecting the data is not covered by a general law. So I am on section 4. I know that there is a duty to protect records and documents pertaining to the identity of people. Does it have to be, Mr. Arya Singh, in the form of documents, or can the institution concerned microfilm or scan and protect it? Because keeping records is going to be a huge problem in the years to come. Can I have an answer for that? I can't hear you.
Thank you, Mr. Indratissa, for that question, which is posing two problems for me. One is that the records is not defined in this particular financial transaction act. Whenever such a problem comes to us, and a number of times that has come to the FIU, and we have advised for on specifically on the purpose of keeping it as a record, yes, as you suggested, microfilms and other magnetic forms and various other methods should be used. But when it comes to that, there is another area that comes into a bit of a problem, where the investigators usually rely on the hard copies, because hard copies have two sides of the record. Now, both sides have certain information. Now, under usual circumstances, a micro or magnetic film will only take one side of the record, basically, which that has all these transcribed, characters, etc. And then they will photocopy it and keep it. Most instances, the other side, which is usually a blank, also has a lot of information. Now, that part is not revealed when you keep it in a magnetic form or a microchip or any other format. So, therefore, that posits two problems. One is the fact that the primary document is not there when you have the chip on or whatever electronic form of data. And more than that, there is, of course, a Data Protection Act, which is on the way. We have seen several drafts of it, and that is, I think, around the corner for Sri Lankan legislation. Apart from that problem is that we have not disallowed it, but practically that has other connotations coming into it in terms of evidentiary and investigative purposes.
Yes, sir. No, I will now on the same thing, Mr. Arya, now under section 4, as you rightly said, there is no definition of what is a record, how to keep a record, right? There is no Data Protection Act. When it will come, we don't know. Then for nextly, one of the other things that is data protection. Now, if you scan and keep, now Electronic Transactions Act permits filing of records through electronic forms. The Electronic Transactions Act 2006 cannot deny the legal recognition of an electronic document. So section 4 is to maintain records and give it to the FIU when they want. So FIU is a government institution. Electronic Transactions Act will apply. So all what I'm saying is now document form, because every transaction, if you expect the institutions to keep, every bank will, if you have more than 1 million customers, that they will have to have a separate building or buildings for that purpose alone. But if you look at section 65 and section 66 of the evidence ordinance, which you can, where secondary evidence is permissible, you can take a microfilm, or you can, of course, subject to the problems that you stated, which is very valid, or scan a copy, or take a photographic image and then have it certified, keep it, and if necessary, you use it. The necessity of using it in a court of law will come if there is an investigation and a prosecution. When that comes, section 65 will apply. Certified copies of secondary evidence can take place. So I think this is a discussion that we'll have to start and then see in order to give a better mechanism to the law. And thank you for that answer. Thank you.
Thank you, sir. And your points are we have already taken that into several discussions, and thank you again for raising it up.
There are a few more questions from the audience. So today the new finance bill was passed, if I'm not mistaken. And so the question is, with the passing of the new act, I think passing of the new bill today on legalization on undisclosed assets, as banks, how do they ensure to capture this when opening accounts? That I believe the question is probably asking, if you disclose assets that have not been disclosed before, how do banks capture that? The question reads, with the passing of the new act today on legalization of undisclosed assets, as banks, how do they ensure to capture this when opening accounts? Anyone? Mr. Arya Singh probably.
No, I don't know whether there was a finance amendment which was passed today.
There's a bill that passed today.
Yeah. There was a bill passed on, yes.
Which paves the way to legalize undisclosed assets.
Well, there is, I'll take this partially because it has not gone through the full application stage, because that's where the Inland Revenue Department has a large say in the matter through regulation and formats and whatnot. So I'll take it partially. Partly the monies which have not been declared for inland revenue purposes, they have identified several legislations in that capacity, what should fall within the amounts identified. The monies which were not declared under those specific statutes, for example, the value-added income law, etc., income tax law, etc., and where that money is concerned, where you're bringing in money through, there is a time frame. There's a small time frame of up until 31st of December 2021. Up until 2021, you can bring in this money, and that money should be according to certain transactions. So you can put it into property market, you can put it into public debt, which means government debt market. You can also invest it within the share market or any other company, they've given certain categories. Apart from that, if you don't want to invest, what you can do is you can place that money within a financial institution, basically a bank. That is before December 31st, 2021. Now that window, once it closes, that's it. Then all of these monies that are bringing in are subject to 1% of the tax, which is, will be assessed. Only 1% of tax will be given on that. Apart from that, everything else will be applicable. I think I answered most. If there is no drastic changes from what I have seen at the last stages after the special determination was over, I think that would be suffice, Mr. Amir.
I believe this question to a certain extent was already answered by Mr. Arya Singh, but the question is the KYC form used by commercial banks in Sri Lanka sufficient to cover the requirements of the Financial Transactions Reporting Act and the Prevention of Money Laundering Act? If you could just touch on that again.
One thing is that should be sufficient. And again, if any institution or an individual feels that there is any suspicion, they can always raise a STR. And there is no finance amendment bill does not preclude any of those reporting.
Another question we have is, why has Sri Lanka been ranked the 23rd riskiest country for money laundering and terrorist financing in the BASCL AML Index 2020?
I'm sorry, could you cite that number? What's the ranking?
23rd riskiest country for money laundering and terrorist financing.
23rd riskiest. Unless someone cites that report, we look at the Financial Action Task Force. And Financial Action Task Force is the global policy setter where all jurisdictions are identified and ranked. And we did enter the grey list in 2017 October. And at that point of time, of course, someone could point the finger at us and say, you are in Sri Lanka, and Sri Lanka is ranked as a high risk, or rather country where certain actions should be taken, right? But no longer. We are not a high risk or a risk country where we have exited grey list in 2019 October, and from the EU blacklist in 2020 April. So I think that assumption, maybe Basel must be following certain different criteria, but right now that will not be the case for Sri Lanka.
Okay, so the final question, I think Mr. Indradis or Mr. Arya Singh could touch on this, is about cryptocurrencies and the application of money laundering in Sri Lanka. Do we have any legislation, or what are your thoughts with regard to cryptocurrencies and money laundering? So you're on mute.
Now, as far as cryptocurrencies are concerned, my feeling, my individual and personal feeling is cryptocurrency is a very easy method of money laundering. Cryptocurrency, nobody knows where it would go, nobody knows where it is stored, nobody knows how it will happen. You identify a unit called cryptocurrency and try to invest or utilize that concept to develop and enhance your assets. In my opinion, that is an ideal mechanism of money laundering. Sometime back, even the Bar Association had a seminar on this, and I had my reservations, even though I was president at that time, on the question of whether cryptocurrencies are suitable for a country like Sri Lanka. And there were several people who were trying to advocate this. But I can foresee, we foresaw that cryptocurrency would be definitely a mechanism which will be used by the launderers to turn and convert, to store money as a storage. I don't think the central bank also has recognized that concept. I think there was a circular which was issued, or a letter that was issued on cryptocurrency by the central bank in somewhere in 2018 or 19, dealing with that issue and not identifying that as an approved mechanism. And it was on the watch. I believe Mr. Arya Singh will be in a better position to educate us on that. Yes, Ash.
Yes, you're correct, sir. It was somewhere in 2020, we issued a press release saying, because there were certain trends emerging that people may have used payment devices to transact in cryptocurrencies outside the jurisdiction, because within Sri Lanka, there is no kiosk or any other agency that can transact or convert cryptocurrency into the Sri Lankan currency. So yes, Sri Lanka has not identified the cryptocurrency as a legalized payment device or transaction method, and there is no laws as of now giving it legal validity. So I do feel if this takes place, if we open that door, that will be a door that we will be unable to close and have far definite repercussions down the way.
So there is a need, I believe, for some legislation in relation to cryptocurrencies. There is an urgent need. Am I right to say that, if I say that?
I would put it this way. If we prevent cryptocurrency, if we say Sri Lanka is not a jurisdiction that accepts or recognizes cryptocurrency, that should be sufficient.
Enough. Yes. Yes.
Thank you very much, gentlemen. I believe this has been an extremely informative session. I personally really enjoyed, and I learned a lot. And I'd like to thank all of you, including AmCham and Rai, for organizing this. And I'm sure the audience also would have a lot that they would take back after this session. Rai, over to you.
Thank you very much, Amir. And yes, absolutely. I think that was a very, very insightful session that we just concluded. So of course, this brings us to the end of yet another timely, topical, and extremely, I think, insightful episode of the AmCham Sri Lanka Legal Review Series. As you know, of course, this series is created and curated to bring both academic and empirical insights into the legal issues and matters that are business relevant to you, and to the continuous and positive trajectory of your business despite any challenges of this fluid business environment. Gentlemen, on behalf of AmCham Sri Lanka, my sincere appreciation for the time and insights shared with our audience this evening. I'm actually wondering if we should have a part 2 on this topic, and also maybe bring in a discussion on cryptocurrency on that. So let's see, let's kind of have the events team mull that over and maybe get back to you. To our participants on Zoom and our viewers on Facebook and YouTube, thank you for your participation. Don't forget to watch, like, and share the video widely, as well as to subscribe to the AmCham Sri Lanka YouTube channel, which is what will help us continue to bring these invaluable online resources to you free of charge. Before we go, our heartfelt reminder, as always, from the panel, from the AmCham team and myself, to keep our physical distance, masks on, hand sanitized, immunity boosted, fingers crossed, and spirits up. Stay safe, everybody. Good night and God bless.